Shirjan, Elizabeth. Okay, next we're going to have the municipal court update, and we have Judge Joy Goldbaum with us. Judge.
Good afternoon. Happy Lunar New Year, everyone. I am Judge Joy Goldbaum, Municipal Court.
Excuse me, Judge, can you speak into the microphone, please?
Sorry.
Thank you. No
Is that
problem.
better?
Yes.
Okay. I'm Judge Joy Goldbaum from the Las Cruces Municipal Court, and assisting me today is Don Schultz, one of our court managers. I was really hoping that Miguel Munoz would come, partly because I wanted to give him a really big shout out. He took my scrambled handwritten notes and turned them into these slides and did just a really good job. I hope that after my presentation today, you will agree with me that the courts do have a role to play in the quality of life for residents of Las Cruces. I'm also really glad, I saw Mr. Garcia. Oh, you're still here, thank you. I'm glad he's here because I did want him to know that I take his criticism seriously. I can't always act on that in a way that he would like, but I do listen. So basically, I'm going to click pretty quickly through some of these slides. They're kind of for your reference only, and I have a few miscellaneous comments at the end. So the first slide is what we're covering, the definitions. You can look at that at your leisure. I wasn't sure how familiar people were with what happens at the court, the procedure, the terms we use. I think the two I would just kind of draw your attention to are penalty assessment. That's most traffic offenses, things that people can sign the ticket when they're stopped and agree to pay it within 30 days. And arraignment is also called first appearance or initial appearance. We are generally doing those remotely still, but they can be done in person. And what happens at the first appearance is the person learns the possible penalties if they're convicted, including a plea, their rights, and what the pleas are. Also, on criminal or charges facing potential jail time, they are informed at that time that if they are convicted of a jailable offense, it could have a negative impact on their immigration status up to and including deportation. So the next slide, again, just for reference. Usually a traffic stop is the first thing that happens, and then the person can basically ask to go to court, or they can sign off that they'll pay the ticket. It's an admission of guilt. And you can look at that a little more at your leisure, but it's pretty self-explanatory. The next one is the criminal citation life cycle. A little more complicated because these potentially carry jail time, most of them up to 90 days and up to a $500 fine. That's also true of codes, ordinance violations. And I just went ahead and did, oops, sorry. I think I'm forgetting to move ahead. I included DWI separately just because it really is a different animal. The fines are stiffer. Everybody's convicted is required to complete a year of supervised probation, and that is done through our county compliance office. You can see there are increasing jail time as you go up in the number of DWI convictions. Anything after a fourth could not be handled in municipal court, would have to be in district court, and it's a felony. The one thing I wanted to add, under medical use of cannabis, there is one exception, and that's if the person has a qualified user designation card for a medical condition, and they have to present that to the county compliance office. Otherwise, they cannot use cannabis or be in cannabis establishments. Just a general snapshot of the cases filed between 2016 and 2022. There wasn't anything scientific about why I picked those dates, but I didn't want to give Miguel a full-time job creating slides. So I started with 2016, and you can see in 2020, COVID hit, and that's when the number of cases being filed hit. It's very gradually creeping back up. The next slide is from 2016, a breakdown of what was filed, and I think maybe the most important thing is to look at the totals, the grand total. And if you want to look at the police department, that total is on the right. Same with 2017. 2018, totals again, 2019. And then 2019, the filings by month, just to kind of give you an idea that it's up and down generally. 2020, there's our grand total, and the police department total. And the number of filings by month. So you can see in 2020, if you look at March, obviously when the pandemic hit, at the very beginning, things really started shutting down. Courts were not permitted to close in New Mexico, and we never closed. We did have to transition to doing a number of things remotely, and we learned that some things work really well remotely, and some things are really difficult to do remotely. So we've gone back almost entirely to doing things in person. There are still a few exceptions. Sorry, I keep forgetting to go forward, but hopefully you were able to see that. 2021, total number of cases filed, and then by month. And 2022 through December are totals. Number of filings by month. You can see that it's just up and down. No real rhyme or reason. Office Chief may have an idea and want to weigh in on that in a minute, but the next case is dismissals in 2022 by agency. And I only broke this down for 2022 because it was really time intensive for Miguel to go back and try to collect this data. We don't really keep track of it in this nice, neat way. To my knowledge, these agencies don't. So he basically just had to go through and look at every docket, but he did a nice job coordinating that for 2022. And you can see the totals on the right. noli pros is a dismissal by a prosecutor. If you have any questions about any of those, certainly you can come back to that. I've marked it as slide 19. And then here's just a nice picture snapshot of those dismissals and a little nice graph that he did by agency. All right, this slide, police hours by month. We don't actually collect this data. I'm going to come back to this slide in a little bit. So I asked Miguel to try and come up with something, and he and I together sort of decided from just being in court, we would calculate it this way. It's not going to be exact, but no agency, including the court, keeps this information. So basically what we did is if an officer has to come to court, usually it's for a pretrial hearing, there are other things they come to court for, but we just assume it's going to be 30 minutes, give or take, because about 10 minutes of their time to get there, about 10 minutes to take care of the pretrial hearing, if they're able to, about another 10 minutes roughly to go back to whatever they were doing on their shift. So you can see it's probably pretty conservative. If an officer's appearing in court on the same day and time for multiple defendants, we just went ahead and added 10 minutes. So again, it's not scientific, but I wanted to try to give you some idea of the amount of time that officers actually spend in court. I've marked this as slide 22, and I will be coming back to that. All right, this is a slide I think I've presented, or a sheet I've presented previously. It's the cost per year that we have paid out for alternate judges. And on the bottom line, 2023, that's the city year that starts July 1. So that's only July 1 through December 31st. It's not a full year. We haven't received their invoices yet. All right, the next slide is another one that I'll come back to and harp on a bit. This
in November
is
of 2022,
what we've
the
spent
cryptocurrency
since 2016 for the panel attorneys that represent indigent defendants. So if somebody can't afford an attorney and they're facing jail time, they can apply for an attorney through the court. We do not use the public defender. We have these right now 5 attorneys, and we round robin them. They're all bilingual. So you can see 2016, it was pretty minimal. 2017 shot up, 2018 hovered a little below that. And then since then, we are spending well over $110,000 a year on indigent attorney representation. And there's a number of reasons I would like to get rid of this system, and it is one thing that I'll talk about at the end. If you look at 2023, the 81,000, that's because it's only July 1 through November 30th. So if you double it roughly and add a little to it, you'll see that we're going to be really close to that 180,000 again. All right, so the handful of things that I wanted to say about COVID, just for you to see what happened when it hit. My staff did an amazing job getting us set up to try to do everything virtually. It wasn't easy, but we kept the court open. All courts in New Mexico, it doesn't matter if they're a city court, state court, all courts in New Mexico fall under the New Mexico Supreme Court. And the New Mexico Supreme Court in March of 2020 issued the first of, I'm going to say, maybe 24 orders detailing exactly what courts could and couldn't do. the masking, the distancing, the, the plexiglass. It was a lot that we had to do, and we did it, and they would revise it maybe every 2 months, send us out a new order. Even though the city and state both had different COVID protocols, and some of them were fairly strict, but the courts are stricter and they're still in place. So even though the city and pretty much the governor don't really care if you wear a mask, when you are in a court, you do have to wear a mask. That's from the New Mexico Supreme Court. It cannot be a neck gaiter, a bandana, or a mask with an exhaust valve. And that's in courtrooms and in jury rooms. We don't have juries, so we don't have jury rooms. But we are still doing 3-foot distancing and masking at the court. Every court in New Mexico is supposed to be. And we take it pretty seriously. We provide a mask at the door to people if they understandably show up without a mask, because most people aren't masking anymore. There was a really interesting legal issue that came up during COVID. And I don't know if Ms. Garrison would like to weigh in on this, but what happened was at the beginning, we couldn't have in-person trials. We had to have them virtually. We were using GoToMeeting. So some defendants and attorneys were okay with that, fine, we would do them virtually. We did a number of trials virtually. We are required to complete a case within 182 days from that initial appearance, the arraignment, to its conclusion. That was obviously not going to be possible with some cases unless people agreed that we could do them virtually. And some defendants and attorneys refused. They said, defendant has an absolute right, and they do, a constitutional right to confront the witness against them, and we demand our in-person trial, even though the courts weren't letting us do that. So from the period of like mid-March 2020 until early June 2021, we didn't have any in-person DWI trials or other trials, but DWI was the real issue. And there is a rule in the New Mexico Municipal Court rules that allows a judge to make a finding that due to, what's the word, Jocelyn? Circumstances?
It would be exceptional circumstances.
The exceptional, thank you, circumstances. The court could simply say, we cannot do it within 182 days. And so it's continued indefinitely until we can. A number of these cases went up on appeal. Appeal from my court is to district court, but there's no single judge at district court that hears them. I think they round robin them. So some judges said, the municipal court absolutely should have had these in-person trials during the 182 days, even though we didn't have permission to do them yet. I think at least one judge agreed with our exceptional circumstance order that I was doing and said, no, that's reasonable. Ms. Garrison, do you know if any of these have gone up beyond district court to the Court of Appeals?
No, Judge Goldbaum, we did not appeal them, and as far as I know, the defense attorneys didn't either, and it was the chief judge that agreed with you, actually.
Okay, thank you. So it was kind of scrambled all over the state, and I don't know how it was in other places, but those district judges that said you absolutely had to have given them an in-person trial within 182 days, and now it's dismissed. So we lost some of those on those grounds, and I don't know, another part of the state may send one of those up on appeal, so it'll be interesting to see how that comes down. Oh, here's the language from the rule. Upon a determination by the court that exceptional circumstances exist that were beyond the control of the prosecution or the court, that prevented the case from being heard within the time period, and a written finding that defendant would not be unfairly prejudiced, the court may grant further extensions that are necessary in the interests of justice. So I felt that COVID was an exceptional circumstance and wrote, gosh, probably 30 or more of those orders, and a few of them did go up on appeal. All right. I'm going to shift now to competency and then mental health. Our state statute regarding competency, and I'm sorry I don't have this on slide, but I can get it to you if you would like. It's the state statute 31-9-1, determination of competency, raising the issue. Whenever it appears that there is a question as to the defendant's competency to proceed in a criminal case, any further proceeding in the cause shall be suspended until the issue is determined, unless the case is dismissed upon motion of a party when the question is raised in a court other than the district court. The proceedings shall be suspended and the cause transferred to the district court. So I frequently have people come in front of me that I know have previously, maybe within the last month, been determined to be not competent to stand trial. So in that situation, I am required to make a referral to district court. It doesn't have to come through me. It can come through the jail, a defense attorney, a prosecutor. But once that referral is made, and it's usually made when the person is seen frequently at the jail, it goes to district court and I lose jurisdiction. Now, I recall a few months ago, Sarah Smith raised the issue correctly that I was dismissing a lot of cases of people that were cited for trespass and shoplifting primarily. Those names were people who had been recently found not competent. And if the district court decides they're not competent, it gets sent back to me and I am ordered to dismiss the charges and release the person. So it is not my decision. Municipal courts have no authority to make that decision. But there are probably about a dozen people in our community, mostly men, a couple of women, who frequently get referred for competency. I transfer it to district court. The district court has to order an evaluation by a psychologist, unless one was done recently, and that's frequently the case. And then the person's found not competent again. I'm ordered to dismiss the case and release them. Yes, they do sometimes go out the same day and shoplift and trespass again. So here's what's required for that determination. This is 39-9-1.1. The defendant's competency shall be professionally evaluated by a psychologist or psychiatrist or other qualified professional recognized by the district court as an expert, and a report shall be submitted as ordered by the court. And then a hearing on the issue of competency of an incarcerated defendant charged with, well, that's a felony. We don't have felonies in my court. So then it starts getting into the time limits that we have. But basically, if the person's incarcerated, they have to be evaluated within 30 days. If they're not, there's a little more time. We have a couple of psychologists on contract with district court that can perform these evaluations. But the court doesn't always order a new one because they cost in excess of $1,000 each. And understandably, the district court's not likely to order another evaluation if just 3 months ago one was done and the person found not competent. What is competency? The crudest sort of test for it is what's called the Georgia Court Competency Test, which is whether the defendant has sufficient present ability to consult with their lawyer with a reasonable degree of rational understanding, and whether he has a rational as well as factual understanding of the proceedings against him. Again, I don't make that determination. Pretty much it's in the report that's done by the psychologist, and then the district court makes a ruling on that. I think right now they're all being heard by Judge Martin. All right, here is what the municipal court rule says about insanity or incompetency. It's Municipal Court Rule 8-507. If a defendant pleads not guilty by reason of insanity, or if an issue is raised as to the mental competency of the defendant to stand trial, the action shall be transferred to the district court for further proceedings pursuant to the rules of criminal procedure for the district courts. The municipal court shall retain jurisdiction over the defendant and conditions of release until the action is filed in district court, which is usually the same day as the referral is made. So that's a kind of quick summary of how competency works. And unfortunately, whether I agree with it or not, but a number of defendants do spiral constantly through that system. All right, now I'd like to talk to you a little bit about mental health issues in the court. Because the municipal court is a misdemeanor court, we get a lot of people that have a variety of mental health challenges coming through. And so I included with my presentation, I hope some of you got a chance to glance at it, some information about the Miami model for treating mental health concerns. It's kind of the gold standard, but it's been in place for a while, and it was expensive, to get there. So what do communities that don't have that kind of money? By the way, if you haven't read it, it's really inspirational because, it's just phenomenal how well it works. But like a lot of treatment courts and other programs, it's not a quick fix. It takes a while, and sometimes people have to go through it more than once. But what we are doing here in Doña Ana County is just trying to fill the gaps from the initial interaction with a person in crisis, probably it's through law enforcement, all the way through to the end of a case if it results in criminal case. So often it does. And what we are doing locally, actually, let me back up and say that a few years ago, Chief Justice of the Supreme Court, Nakamura, and District Judge Angie Schneider in Otero and Lincoln County got together to try and address this issue of the mental health crisis going through the courts and the jails. And so what they came up with is to use a program that's been tried and true in other places. It's got kind of a weird name. It's called the Sequential Intercept Model, or SIM, and it's used to assess available opportunities, determine gaps in service, and plan for community change. These activities are best accomplished by a team of stakeholders that cross over multiple systems, including mental health, substance abuse, law enforcement, pretrial services, courts, jails, community corrections, housing, health, social services, peers, family members, and many others. You can see that's a lot. So at the Criminal Justice Coordinating Council, which is a group that meets once a month to talk about things that affect the courts and others in law enforcement, it was determined that we should attend or create a SIM, sequential intercept model workshop, and we did that last June. There were probably 40 or so participants, and it was a full day. I think it was a day and a half, actually. And somebody from SAMHSA came to talk to us about it. SAMHSA is Substance Abuse and Mental Health Services Administration. It's a department of our Federal Health and Human Services. So they publish materials and present programs on anything and everything to do with mental health. So a number of us attended this workshop, and after that workshop, a smaller group of us decided we wanted to be a task force to try and really focus on filling these gaps. So I'm on that task force. Judge Arrieta is. We have probation and parole, lots of law enforcement. People from the university are working with us. I see that Jamie Michael's here today. Thank you, Jamie, for being here. I may have you field some questions, okay? And anyways, a number of us, we meet every 2 weeks for 2 hours, and what we're trying to do is come up with evidence-based systems to fill in these gaps. So that means really collecting a lot of data at the beginning. And we have some really great number crunchers working with us from the university and other places. So Jamie is one of the co-chairs of our task force, and the other is Kristen Drake, who is from the Peak. And so I'm just going to very quickly go through what the intercepts are. It goes 0 to 5. Intercept 0 is community services, which is probably crisis lines and crisis care continuum. Intercept 1 is law enforcement, so 9/11 and local law enforcement oftentimes leads to an arrest. Intercept 2 is initial detention and initial court hearings, first appearances, so that involves the courts. Intercept 3 also involves the courts and jails, specialty courts, jails, dispositional courts. Intercept 4 is prison and jail reentry, and Intercept 5 is parole and probation. And one of the really big themes behind SIMS is not just to give somebody short-term help and then boot them out and say, you're good now, because it doesn't work and it can't work. So we don't have the kind of building, the kind of facility that Judge Leitner had in that article that I attached. But we are still working like crazy to fill these gaps. And I think it was Councilor or Mayor Pro Tem Gondara last week who referred to the Z team. Was that you? Somebody referred to the Z team. The Z team is that group that initially started with Justice Nakamura and Judge Schneider and a few others, some people from the Administrative Office of the Courts. And the Team Z is to represent the 0 intercept, because that is the very beginning where most of the contact occurs. And the goal of this is to keep people from having to go through the jail and the court systems, because when you're suffering a mental health crisis, it doesn't get better if that's all you get, is charged and sentenced and so on. So if you looked at that article on Judge Leitner, it's a law review article, and it really did a great job identifying how well that Miami model works. But we think locally here on the task force that we can fill a lot of these gaps with local services. And in October, a number of us went to I guess it was a convention. What was it? A symposium. Thank you. Do you want to come up, Jamie? Come on. And had a number of really good presenters. They showed some videos from Judge Leitner. And And it turns out Doñana County, every county in the state, is trying to do something with Sims. But we are way ahead of the curve, and we still have very far to go. But other counties are contacting us regularly and saying, how do you do this? Where can we get this? And Doñana County's lucky to not be a super rural county. Yes, we do have some outlying areas, and we understand it's much harder to provide services sometimes there. So, I mean, we're looking at including transportation, anything and everything anybody would need to fill these gaps. What did I leave out? I think you got it. Okay. So we're having a summary meeting this Friday